20 years after Cummings, the Supreme Court heard a case that went directly to the heart of forfeiture. E.A. Boyd and Sons were importers accused of evading customs duties on plate glass. The government sought to forfeit their goods, and to prove its case, the government invoked a statute that allowed it to compel the Boyds to produce their own invoices, to hand over their private business records to be used against them. The Boyds objected. They said this compelled production violated both the Fourth Amendment's protection against unreasonable searches and seizures and the Fifth Amendment's protection against self-incrimination. The government responded with what had become the standard argument. This is a civil proceeding. These constitutional protections apply to criminal cases. Forfeiture is civil. Therefore, the protections don't apply. The Supreme Court rejected this argument unanimously. All of them said no. Justice Joseph Bradley, writing for the court, looked past the labels to the substance. He went beyond semantics and looked at rights. Yes, he acknowledged, the forfeiture proceeding was technically civil. Yes, it was in rem against the property rather than the person, but these technical classifications did not change what was actually happening. We are clearly of the opinion, Bradley wrote, that proceedings instituted for the purpose of declaring the forfeiture of a man's property by reason of offenses committed by him, though they may be in civil form, are in their nature criminal. In their nature criminal. Not technically criminal, not labeled criminal, but in their nature, in their substance, in their reality, criminal. Bradley called these proceedings quasi-criminal. They were close enough to criminal prosecution that the constitutional protections should apply. You could not evade the Fourth and Fifth Amendments simply by calling a proceeding civil and directing it at property rather than a person. The court had looked through the form to the substance. It had refused to let the government escape constitutional limits through clever labeling. Boyd versus United States should have been the end of the story of forfeiture. The court had said clearly and unanimously that forfeiture proceedings are quasi-criminal in nature and that constitutional protections apply. That the Bill of Rights meant what they said and could not be avoided by using different labels. But, as we all know, it was not the end of the story.